Hello, ladies and gentlemen. Thank you for standing by. Welcome to the webinar today, brought to you by ComplyRight. DOL announces new overtime rules, what you need to know and do to comply. Please note that during the presentation, all participants will be in a listen-only mode. My name is Stephanie Thomas, and I am your host today. Thank you, everyone, for attending this webinar, and welcome. I'd like to review a few housekeeping items before we begin. If you would like to ask a question, simply use the chat feature located in the lower left corner of your screen. Ashley will try to answer a few questions as they come up during the presentation. If you have any audio trouble, please message us in the chat box and we will assist you. Please ensure your speakers are turned on with the audio up, with the volume up. Now I am pleased to introduce you to our speaker today, Ashley Kaplan. Ashley is the Senior Employment Law Attorney for Poster Guard and has been practicing labor and employment law for 20 years. Ashley oversees the teams responsible for researching all the posting laws and developing Poster Guard services to meet our customers' diverse needs. Ashley has represented employers of all sizes in all areas of labor and employment law, including claims relating to civil rights, family leave issues, wage and hour matters, immigration, and breach of contract. And without further ado, here's Ashley Kaplan. Thank you for being here today.
Thank you, Stephanie, and welcome everyone. I've really been looking forward to this webinar today, not only because this is such a major employment law change affecting so many people, but also because this is a law surrounded by so much confusion in general. It's really misunderstood. And I look forward to sorting things out and hopefully clearing things up for you today. So this new overtime rule, the new Fair Labor Standards Act overtime rule that we're going to talk about today, is arguably the biggest federal employment law change since the FMLA came out about 25 years ago, back in 1993. And the change in the actual regulations really is pretty simple and straightforward. And the new regs are actually just a few pages. But the impact is huge. And I mean huge in terms of the effect on employers, on businesses of all sizes, and on the public. It will essentially change the way millions of workers in the U.S. will be paid. So the simplest way to describe the new rule, and we're going to get into all the details and the nuances, but very simply put, because of this new rule, starting December 1st, 2016, most workers making less than $47,500 a year will now have to be paid on an hourly basis, where they have to keep time records and get overtime if they ever work more than 40 hours a week. They can no longer get paid on a fixed salary for all hours of work. So today we're going to cover the specific changes in detail, the impact of the new rules and what they mean to you. We'll also cover some exceptions to the rule. We're going to go over what you can start doing now to prepare for the December 1st deadline. Options to consider for employees affected by the change, and you do have some options that we're going to go over. We're going to talk about the pros and cons, and even some alternative pay arrangements to help keep payroll costs down and employee morale up. And finally, we're going to go over a specific action plan covering everything you need to know and do when converting affected employees from salary to hourly with overtime. Everything from communication to documentation and general compliance tips. So here's a little background on how the rule came about. It's actually been brewing, so to speak, for a couple of years, but most people were shocked to see it actually come to fruition when it was announced as a final rule. So this started back in 2014 with a directive from President Obama to the Secretary of Labor, and the directive was to update the FLSA overtime regulations. The memorandum, it specifically said to modernize and simplify the rules so they're easier for workers and businesses to understand and apply, and to further the goals of the administration, which the goal is, quote, to ensure a fair day's pay for a hard day's work. So on July 17, 2015, the Department of Labor issued the proposed regulations. And as expected, they generated an overwhelming public response. The DOL actually received more than 270,000 written public comments that they reviewed and went through and considered before coming up with the final rule. Actually, the proposed rule was even more burdensome on employers than the final rule, and I'm going to point out the differences as we go. So there were some changes. But the final rule was announced by President Obama and Secretary Perez on May 18th, 2016. And the compliance deadline, the date when all employers have to make all the mandatory payroll changes and get in full compliance, is December 1st, 2016. And even though there's a lot to do, this is actually a pretty generous compliance window. It's a little over 6 months, especially when you compare it to the proposed rules, which were only going to allow for a 60-day period to comply. So that's good news. So why did this rule change come about? I mentioned the basic objectives: to clear up confusion about the law and simplify the requirements around who can be paid a salary without overtime and who cannot. But the main purpose, according to the DOL, was really to put more money into the pockets of middle-class workers, that's a quote, by increasing the number of workers who are eligible for overtime. So this slide lists out the specific objectives that the DOL published as the reasons for the rule change and all the positive effects that were intended. It includes things like improving work-life balance and workers' health, and preventing injury associated with long work hours. And then there are these last two bullets, which I think may be the most controversial. One is that it will reduce the national unemployment rate by creating new jobs. And the other is that it will increase productivity through improved employee morale. So as we go through the actual impact this new rule will have on your business, you'll see why these two are so highly debated, why they're so controversial. They're really based on a lot of assumptions about how businesses and employees will respond, and those are assumptions that a lot of people disagree with. So here are the actual stats that were published, and these are the Department of Labor's estimated projections on the economic impact of the rule. So first, the new rule is expected to automatically extend overtime pay protections to more than 4.2 million workers within the first year of implementation, just within the first year. The DOL projects that another 9 million or so workers will be indirectly affected because the new regs will help raise awareness and correct misclassifications. So those, now we're talking about people who have been paid on a salary basis without overtime who didn't really qualify even under the old rules. The DOL estimates that more than 7.4 million businesses will be directly affected, meaning they will have to make changes because of the law, because they'll have employees eligible for overtime who previously were not. And this will result in a net transfer from employers to workers of about $1.5 billion. And then this last stat here, this is the estimated amount that employers will spend just to get into compliance, not counting the economic effects on the business. And that's estimated at around $593 million. And by the way, in coming up with that estimate, the Department of Labor figured it would only take a business an average of 1 hour to learn and understand these new rules, which most people would say is a gross understatement, especially when you consider that most employers don't understand they don't even understand the underlying requirements already in place that are now changing. So this is the projected impact according to the DOL, and I'm going to get into all the ways this new rule really affects employers as we go. But first I want to explain the law and what exactly changed so you can get a better idea of how significant it'll be for your specific business. So in talking to people over the past couple weeks about this new law, I've come to realize how many businesses and managers don't really understand the basic concept of exempt and non-exempt in the first place. And without that, it's really impossible to make sense of this change and how it affects you. So I'm going to back up and just give a very high-level overview of some FLSA basics and what it even means to be exempt in the first place. So first of all, who does the FLSA apply to? I wanted to get this out of the way. I'm already seeing a lot of questions. I'm going to try to address them as I go if there's something that would be relevant to everyone. But I could have included a whole slide on the statutory definitions of enterprise coverage for the business and individual coverage for the employee. But the bottom line is that this law applies to nearly every business and every employee. There's no employee size threshold. It applies even if you just have one employee. And based on the statutory definitions of enterprise and individual, the coverage is so broad that it's safe to say that all of you are covered, and if you're not, your individual employees are. The exceptions are really so narrow. If you're going to take the position that the law doesn't apply to you, you would definitely want to work with a labor and employment attorney, because like I said, the exceptions are very slim. And also there are state laws, state laws that mirror the FLSA, and they could have an even broader application, and they could cover you. So you'd have to look at that too. So here's what you need to understand about the FLSA. The default rule is that minimum wage, overtime, and record-keeping requirements apply to all workers unless an exemption applies. And I'll explain what I mean by an exemption. It's based on strict legal criteria, and it really doesn't apply to that many people. So the default rule is that every employee must keep accurate time records of all hours of work. They must get at least the minimum wage for every hour worked, and they must get paid an overtime premium at the rate of time and a half the regular rate for working more than 40 hours in a work week. And this has been the law for decades. There's nothing new here. Now, the only time these minimum wage, overtime, and record-keeping requirements do not apply is when an employee qualifies for an exemption. And there are very specific exemption tests that have to be established for someone to qualify as exempt. So exempt basically means exempt from the law's minimum wage, overtime, and record-keeping requirements. Some people say it more loosely as overtime exempt, if that helps you to keep it straight. But the key here is that exempt status is not available to everyone. If an employee qualifies for an exemption, then and only then can you pay them a salary for all hours of work without overtime. On the other hand, if the employee does not meet the law's requirements for exempt status, you have no choice. You must keep accurate records of their time and track their hours so they'll get paid properly for all hours of work plus overtime. So if an employee qualifies for an exemption, you may pay them on a salary basis for all hours of work without worrying about overtime. And this is just an option. You're never required to pay anyone on a salary basis. A lot of employers choose to take advantage of this option and prefer this arrangement, and that's for a few reasons. The most obvious is you don't have to pay overtime, and you can require the employee to work as many hours as are necessary to get the job done without having to track their hours and pay extra for the extra work. Also, employers just feel like it's easier administratively to pay on a salary basis. You don't have to mess with time cards and all that. Another reason, some employers feel that it's an important status thing for their employees, like an incentive that you encourage your employees to work toward. As they climb the ladder up to management, they may look forward to the flexibility that's associated with salary, as opposed to punching a clock. So we all know why employers want to pay their employees on a salary basis, but the problem is the law only allows you to pay certain employees that way. So what are the legal criteria for exempt status? There are actually several exemptions available under the FLSA, and each one has its own legal test, its own criteria that determine if an employee can qualify for the exemption. The most common exemptions are listed here on the slide, and these are known as the white-collar exemptions. They include what's known as the executive exemption, administrative exemption, the professional exemption. There's also an exemption for certain computer employees and for outside sales. And I'm not going to get into all the details for each of these exemptions and what the specific legal tests are today. I'm just going to focus on what has changed in the law. But I have included them all in these slides, so you don't have to go looking them up in case you're using this as a reference tool. And these slides will be sent out to everyone, so you'll have that. But the important thing to understand about the exemptions is they pretty much all have these three elements in common, these three things in common. First, to qualify for an exemption, the employee must meet the minimum salary level. And this is the part affected by the new rule. This is the big game changer. This is the part that's been increased so drastically by the new rule. And I'm going to cover that next, but for now, just keep in mind this is only one step toward qualifying for an exemption. Second, the employee has to be paid on what is called a salary basis, or for some of the exemptions it's called a fee basis, but it's the same concept. And what this means is that the employee must receive a guaranteed fixed amount, a guaranteed fixed weekly salary, and this cannot be reduced or altered based on quantity or quality of work. So if you're going to take advantage of an exemption and pay an employee a salary without overtime, you have to maintain this salary basis part of the test. So you can't dock the employee for missing work or for times when the business has to close. They get their full salary for every week, that they perform any work at all. There are some very limited exceptions, which I'll include later, when you can dock a salaried employee's pay, but they are very limited. The default rule is they always get their full guaranteed salary amount, regardless of quantity or quality of work. So the salary basis requirement isn't new, but it really causes a lot of confusion. That's why I've included a slide on it later in the presentation, just for your reference. I could easily spend a whole hour just on this one requirement. It's one that employers mess up all the time, and not intentionally. It's just confusing, and a lot of times it defies logic. It really goes against common sense. But the point is, on a salary basis, you're not paying for the employee's time. You're paying for the job to get done. So you don't get to dock their pay if they work less than 40 hours, just like they don't get overtime if they work more than 40 hours. So once you decide to pay someone a salary without overtime because they qualify for an exemption, you have to make sure you maintain this salary basis of pay on an ongoing basis without making deductions, or else you can create serious issues, serious liability issues. If you make deductions, it basically destroys the person's exempt status, and then you're on the hook for overtime pay and other damages, which would be really hard to defend because you would have been paying this person as a salaried employee and you wouldn't have the time records to establish what the overtime even was. Okay, so back to the third requirement here on the list, and this is by far the most complicated. To be considered exempt, the employee also has to meet a specific job duties test, and this is the part that varies for each exemption. This is the trickiest part, so just to understand, even if a person makes well above the minimum salary level for number one here on the list, they cannot be classified as exempt unless they also meet a job duties test. So that means you can have very highly paid employees, even in the six figures, that don't qualify for an exemption because they don't satisfy a job duties test. Again, these are included in the presentation. When you take a look at them, they might look simple on their face, but you really need to go through them carefully and make sure that an employee satisfies all the elements of a test, and you got to understand the definitions behind them. Also, this is really important too. It doesn't matter what the employee's job title is. These job duties tests are based entirely on the employee's actual job duties. Job descriptions, they're helpful, but they don't determine an employee's exempt status either. It all comes down to the actual day-to-day duties and responsibilities. Okay, so what has changed? The biggest change with the new rule is what I've already mentioned, and that's the minimum salary level. And that's the minimum salary level that's required for exempt status under most of the exemptions tests. It was the first of the three requirements that we just looked at on the previous slide. The minimum salary level, the amount that an employee has to earn in order to qualify for salary with no overtime, has been drastically increased by the new rules. It's actually more than doubled. So just to meet this first factor alone, before you even get into the job duties test, this first factor alone will now mean millions of workers previously paid on a salary with no overtime will no longer qualify for exempt status. The minimum salary level has been increased from $455 a week, which comes out to $23,660 a year, to $913 a week, $913 a week, which comes out to $47,476 a year. By the way, in the proposed rules, it was even higher. It was going to be set at $50,000 a year. So employers were relieved that it came down a bit, but this is still a drastic increase, and this is why so many workers and businesses are directly impacted by the new rule. A lot of companies have employees currently paid on a salary basis making less than $47,500 a year, and all these workers have to be reevaluated and most likely converted to hourly pay with overtime. By the way, you're going to hear me refer to the new salary threshold a lot as $47,500. Technically, it is $913 a week. And of course, it comes out to $47,476 for a 52-week year, but I'm just rounding up the annual figure by a few dollars for simplicity. So before this new rule, the salary level was last increased in 2004. That's where we got the $455 a week. And before that, it hadn't been touched since 1970. So this is only the second increase since 1970. The Department of Labor feels that this new salary level is a more appropriate threshold, and that's based on the fact that the old salary level, the $455 a week, is less than the poverty level for a family of 4, and it's only 1.6 times the federal minimum wage. By contrast, this new salary threshold, the $913 a week, will be 3.1 times the federal minimum wage for a full-time worker, and it brings it up to twice the poverty level for a family of 4. So the second change in the new rules has to do with how you calculate the minimum salary amount. So to reach that threshold of $913 a week, you can now include up to 10%, which is up to $91 a week, from other sources, from non-discretionary bonuses, incentive pay, or commissions. So you still have to make sure the regular salary is at least $822 a week, but the rest can come from these other sources. And to include these other types of compensation, they have to be paid out at least on a quarterly basis. Also, by definition, these extra forms of payment have to be from non-discretionary sources. And that means they have to be tied to some type of performance or objective metric, like quality or quantity of work, meeting certain goals or results like sales, or even attendance. What it doesn't include are bonuses that are completely discretionary, completely up to management without any prior expectation or commitment. Things like an on-the-spot spontaneous award, or even an unannounced year-end bonus. Those cannot be counted toward this. If an employee doesn't earn enough of a non-discretionary bonus or incentive payment in a given quarter to retain the exempt status, the new law says you're allowed to make a catch-up payment after the fact. So for example, if an employee's commissions don't cover the difference. But this only works if the catch-up payment is made in the first pay period following the quarter that it's being applied to. If the catch-up payment is missed or it's not made on time, the exemption is lost for the prior quarter, and you would have to pay the overtime premium. The employee loses the exempt status. So most employers feel that this new addition to the law, this little 10% rule, really isn't that helpful when you actually run through compensation scenarios, especially because most employers aren't going to want to run the risk of cutting it that close, where you would rely on the 10% to come from other sources if it puts you at risk of missing the threshold for exemption, and also having to manage catch-up payments that weren't really earned under your compensation plan. A lot of employers don't really see that being that helpful. Okay, what else has changed? The next change with the new regulations only applies to a special exemption, and it's called the Highly Compensated Employee Exemption, or the HCE exemption. This is an overtime exemption that was created in 2004, and it has a higher minimum salary requirement than all the others, but it has a lower, more relaxed job duties test. So the new rule raises the minimum salary level for this exemption from $100,000 a year to $134,004 a year. And to qualify, the employee still has to receive at least $913 a week on a fixed salary or fee basis, and the rest of the compensation can come from non-discretionary bonuses, incentive payments, and commissions. For catch-up payments with this one, the new rules allow you to make a catch-up payment to help satisfy the minimum salary level, but it has to be made within 1 month after the end of the year that it's being counted toward. I've included the test for this highly compensated employee exemption in the slides too, and like I said, it's more of a relaxed job duties test than the others, but it still has to be non-manual work. The only thing that's changed in the test is the minimum salary requirement. So the job duties part has not changed. But this just shows, even a worker making more than $134,000 a year still has to satisfy a job duties test to be exempt from overtime. And that is something that most people just aren't aware of. So what else has changed? What else is in the new rule? The rule also includes a built-in index that will automatically increase the minimum salary threshold every 3 years. And this is a big deal considering it's only been changed twice since 1970. This is pretty aggressive. So for the general white-collar exemptions, where the amount has been set now to $9.13 a week, the amount will increase every 3 years to keep it aligned with this standard. So based on current growth projections, the estimated increases are 51,168 by the year 2020, 55,108 in 2023, and 59,351 in 2026. That's based on current economic projections. So in 10 years, we're looking at this salary threshold going up to about $60,000 a year. That's pretty significant. For the highly compensated employee exemption, the minimum salary level rate will also automatically increase every 3 years on the same schedule. And the goal for this is for it to remain equal to the 90th percentile of annual earnings of full-time salaried workers based on national earnings. So these increases will take place every 3 years, and the first one will be January 1st, 2020. And the new rule also says that the Department of Labor has to announce the new rate at least 150 days before each increase takes effect. So we could be looking for that. And by the way, this is another aspect of the new rule that turned out better for employers than under the proposed rule. In the proposed rule, these automatic increases were going to take place every year. So at least it's been spread out to every 3 years to give businesses some time to plan and adjust. I'm trying to review some of the questions that are coming in as we go to see if there's any trending or anything that applies to everyone. And I am already getting a lot of questions just about the likelihood of this law being challenged. It was something I was going to say toward the end, but I'm seeing it that maybe there's a lot of anxiety around this, so I'm going to go ahead and address it. There's always the possibility of legal challenge with something this controversial. Like right now there's talk of a Congressional Review Act resolution. But any kind of congressional measure, like under the Congressional Review Act, would be subject to a presidential veto. So it's not likely to have any teeth. So while anything is possible, all experts are saying this law is moving full force ahead and will take effect on December 1st. If anything, we could see a challenge come later down the line, especially from the next administration, and especially to this automatic increase every 3 years. A lot of people are saying there could be a stop to that before the first increase takes effect in 2020. But of course it all depends. But at this point we all need to move forward and plan for this final rule to go into effect on December 1st. So what did not change? Like I said at the beginning, the actual changes are not that extensive. It's just the impact of what did change. Basically, nothing else in the law has changed. The most important thing to understand, and this bears repeating, is that the job duties tests have not changed. And this is really important. To qualify for exempt status, remember, the employee has to meet the new minimum salary level and they still have to satisfy the job duties test for a particular exemption. So this means that you're going to have employees making above the new salary threshold, making above $47,500, who will not qualify for an exemption. Like I said, you can have very highly paid workers who don't qualify. And the higher the compensation, the bigger the overtime exposure. So be very careful not to overlook this. Another thing that hasn't changed, that didn't change in the rule, is the mandatory posting requirement. As of today's date, the mandatory FLSA posting has not been updated as a result of the new overtime rules. You're still required to post the latest version of the poster, which has the $7.25 minimum wage rate on it. So next are the slides with the various exemption tests. Again, these are just here for your reference if you want to look back at them to go through auditing yourself. I have gone ahead and inserted the new minimum salary requirements into these tests. So these are all the exemption criteria as of December 1st, not today. These are looking forward. And with each of these tests, the employees have to satisfy all of the criteria that's listed on the slides. So I'm just going to cruise through. This is the executive exemption. It's typically for executives and people managers. Be aware of the requirement here that the person has to supervise the equivalent of 2 or more full-time employees. That's number 3 on this slide. Then there's the administrative exemption, and watch out for this one because this is the one that employers make the most mistakes with. And it's really all in the definitions. This is one that looks simple on its face, but you got to understand the definitions in each of these for each of these factors. This exemption is typically more for back office management roles, like in HR, accounting, purchasing, marketing, and even compliance. But the person really has to be at a level where they're making important decisions on matters of significance using discretion and independent judgment. So it's not that easy to qualify. The learned professional exemption, this one's typically for employees whose jobs require advanced degrees. But it can get tricky too. For example, registered nurses qualify for the exemption, but LPNs do not. Also clerks, bookkeepers, and paralegals typically don't qualify. The creative professional exemption, for this one to apply, make sure the job requires a certain level of artistic freedom. The person has to exercise a certain level of invention, originality, or talent. It can't just be a matter of following guidelines or instructions. Then with the computer employee exemption, be careful with this one. Not everyone, for example, not everyone in your IT department is going to qualify. It requires a certain level of expertise, and only certain activities are covered. It can't just be computer repair or maintenance, for example. And then there's the highly compensated employee test that we talked about. Okay, so these are just the most common exemptions. There are lots of other exemptions out there that are industry specific. Like there are certain ones that apply in the automotive industry. Employees in agriculture have exemptions. There are ones for educational institutions. Some for the entertainment industry, and then lots of other miscellaneous ones out there that could apply to your business. Most of the questions I'm seeing so far are asking about all of these random miscellaneous industry-specific exemptions and whether they've changed. None of the job duties tests have changed for any of the exemptions. But if the exemption requires that minimum salary of $455 a week under the current or the old rules, that has been increased to the new $913 a week threshold. It's just the minimum salary. None of the job duties tests have changed. Oops, got ahead of myself. Okay. There are actually a few exceptions that I wanted to highlight. There are a few overtime exemptions out there that do not require a minimum salary level. In other words, these exemptions allow you to pay someone on a salary basis or otherwise without overtime, even if the person doesn't meet the new minimum salary requirement. So even if they make less than $47,500 a year. And these are not new. They've been around for years, but now they have become even more relevant than ever because these are some of the only exceptions where employees can be exempt from overtime without making that new salary level, without making $47,500 a year. So I just want to mention them quickly. There's no minimum salary requirement for doctors, lawyers, and teachers. They can be paid a salary or by any other method without overtime, even if they don't meet the new salary threshold. Next on the list here is the computer employee exemption. There's a variation on this one where you can either pay the minimum salary level of $913 a week or $27.63 an hour to qualify for overtime exemption. So this is another option that might apply even if the person doesn't meet the new salary requirement. Remember, they still have to meet the rest of the criteria for the computer employee exemption for this to work, though. The other major exemptions that don't require a minimum salary level are these 2 sales exemptions. First, there's an exemption for outside salespeople, and I've included the test on the next slide. But the key here is that the employee has to perform outside sales. I've just put it up. The employee has to be performing outside sales for this one to apply. So that means spending the majority of time at your clients' or your customers' sites. It can't be in the salesperson's office, can't be at your facility, or even from a home-based office. It needs to be at the site of the client or the customer. And the next sales exemption is the inside sales commission exemption. And the important parts on this one are it's only available in a retail or service establishment as defined by the FLSA, and the employee has to make at least half their earnings from commissions for this to apply. Also, this one is just a partial exemption. It's kind of strange. The employee still has to maintain time records because their total compensation has to cover at least time and a half the minimum wage for all hours worked. So every week you would need to make sure that's being covered. If you're going to rely on these sales exemptions and not pay overtime, I would advise you to work with an employment attorney to make sure you've got it right. The tests are pretty strict, and a lot of salespeople won't qualify once you dig into it. So earlier I went over all the government's projections on how this new law will impact everyone, but now let's get into some of the actual effects on your business, the issues that most of you are already worrying about, and then we're going to talk about how to manage them. By increasing the number of workers who are eligible for overtime when they work more than 40 hours in a work week, employers will have a choice. And this is an oversimplification for now, but basically it means you can either increase your employees' salaries to at least the new minimum salary threshold, or you can convert them to hourly pay with overtime and pay the overtime premium of time and a half, the regular rate for hours worked over 40, or you can limit their work to 40 hours in a week. The first two options would directly impact payroll costs. The third option means you'll either have to compromise productivity or you're forced to come up with other creative arrangements to get the work done. It could be restructuring to shift the duties around. It could be having other employees or teams absorb the extra work. Outsourcing the extra work is an option. Or it could mean hiring temps or part-timers to cover the extra work at a lower rate. So whether you're increasing your payroll costs or shifting costs around to get the same work done, it's likely to have an impact on your bottom line, especially if you have a lot of workers that are affected by this. And then there are the employee morale concerns. Contrary to the Department of Labor's projections, not all employees will be happy about these changes. A lot of employees who have worked their way up won't like the stigma of punching a clock, and they're going to feel like it's a demotion. Others won't be happy with the pay arrangement, especially if it means less take-home pay overall, if you're cutting them back to 40 hours. Or it could mean less flexibility than they once had on a salary. And then other employees aren't going to be happy about job restructuring. Some may be asked to absorb more work, especially those who are exempt and not entitled to overtime. So all of these dynamics going on could have negative effects on morale, on motivation, and even lead to increased turnover. Next, there's the administrative burden. As we go over the action plan and what you need to do to comply, you'll see that there's a lot to consider, and it can amount to quite a burden, even if it can amount to quite a burden even if you only have a few employees affected. The more employees that you have, obviously the greater of an impact this is going to have administratively. So hopefully the information that you're getting today and the tools that we're going to recommend at the end of the webinar will take away a lot of that burden, but there's no way around some of it. You can expect to invest management's time investigating who's affected and evaluating options. There's administration required in changing your employee's payroll status. There are employee notifications and communications to think about, policy revisions, training, increased supervisory responsibilities that come with managing non-exempt workers. And of course, there are new timekeeping and record-keeping requirements to consider as well. And we're going to cover all this as we go through the steps you need to take on the next few slides. But first, another huge impact to consider is the increased risk of liability. FLSA litigation has been steadily on the rise for years. In fact, it's ranked as the #1 type of collective action filed in federal court year after year for the past 15 years. And FLSA claims continue to be on the rise, especially in certain states where that's kind of a geographic thing, but it is spreading across the country. Experts and law firms predict that with this new rule, it's going to increase awareness to an all-time high and set the stage for even more litigation and enforcement. And that includes both private lawsuits and DOL enforcement actions. And this is because more employees will be aware of the law's requirements and will be questioning their status. especially in workplaces where employees are getting converted from salary to hourly. And after all, that was one of the DOL's objectives in making these changes. That was, to heighten employee awareness. Employees who continue to get paid on a salary basis without overtime pay may be more prone to question their status. Do I really qualify for exempt status? Should I be getting overtime too? Are these deductions against my salary legal? And believe me, there will still be violations and gray areas with applying these exemptions, no matter how hard employers try to get it right. Employees who are converted to non-exempt status may question their previous status, and that could bring prior violations up to the surface. And as long as they're raised within the statute of limitations, they can still make these allegations. And finally, with so many workers becoming non-exempt, you can expect increased exposure in lawsuits challenging your timekeeping and overtime calculations. And this has always been an area where employers have struggled with legal exposure, especially when it comes to things like managing unauthorized overtime, meal and rest breaks, off-the-clock work, travel time, training, and on-call work. These are all issues you didn't have to worry about for salaried exempt employees, but they are hotbeds for litigation and class action lawsuits when it comes to non-exempt workers. And now there are even newer issues to consider with managing your non-exempt workers, like how to manage employees' time if they work from home, or if they tend to check emails from their phones or from around the clock. People use their phone and check emails or check in. Or what if they work on a tablet or a laptop sometimes when they're out of the office? All of those things count as hours worked for non-exempt employees. And unfortunately, these FLSA lawsuits are very attractive to plaintiffs' attorneys, and that's for a few reasons. For one, they get to recover reasonable attorney's fees. And I've seen cases where the employer only owed the plaintiff a few $100s in unpaid wages, but the attorney's fees were in the range of $20,000 to $30,000, just in a simple overtime case with a single plaintiff. And if you're talking about multiple plaintiffs or a full-out trial, attorney's fees can easily climb into the six figures. Also, the amount of damages that an employee recovers in FLSA lawsuits is also significant. The actual wages owed are typically doubled in a damage award, and the employees can be awarded back pay going back for 3 years, depending on the circumstances. So this can really add up, even if you're just talking about a few hours of unpaid overtime every week. It really adds up. So let's shift to an action plan, starting with what you can do now, the first steps that you should take to manage this law change. Depending on the size and the culture of your organization, consider going ahead and doing an initial employee communication. And this might be something you want to do if you know your employees are already talking about the new law. I know in some businesses employees are already asking questions. In others, they might not have even heard about it yet. But chances are they will, so the timing is really up to you on that. If there are rumblings about the new change, or if you're gearing up to investigate and you're going to need to engage a lot of your employees and managers as part of your fact-finding, which we're going to get to next, if you're gearing up for that, this initial communication is a good idea. And I wouldn't say too much in the communication. I wouldn't say too much for now. There's no need to educate your employees about the details of the law. I would just include a high-level acknowledgement that the new rule was issued, that it might affect the way certain employees in the organization are paid, particularly those who are currently salaried exempt, and that it goes into effect in December. You should also emphasize that this is a federal law change, not a company initiative. And this is something I would start to include in all of your communications right from the beginning. Employees tend to receive these kinds of changes better, and you'll get less backlash if you clarify up front that this is not something the company decided to do on its own. I'd also let them know that some employees may be affected in terms of how they're paid, hourly versus salary, but explain that an employee's compensation amount is only one factor that has to be considered. And I think this is also really important throughout the process, to let employees know that it's not all about this magic salary level that they might be hearing about, this magic number, 47.5. One thing I've already heard employees saying is that now everyone's going to know who makes more or less than 47.5 based on whether they're going to be punching a clock. And that is not necessarily the case once you consider all the other factors that are involved. Also give them a heads up that management will be following up with employees in affected business units. And finally, let them know that they will be communicated with appropriately if there will be any changes that directly affect them, that you will follow up with them before any changes actually take effect in December. So just try to keep it positive and informative. Nothing more really needs to be shared until you've made decisions about who's actually going to be affected. So this is just sort of an initial communication, just an initial employee memo. Next, you'll want to start evaluating the potential impact that these new rules will have on your business in terms of staffing and payroll costs. And that starts with identifying affected employees. I would organize the data based on how you're structured, so maybe by business unit or by department, and group similar jobs together. But you really want to focus in first on the employees directly affected. And those are your employees who are currently classified as salaried exempt and who are making less than the new salary threshold. Actually, instead of just looking at everyone making less than $47,476 a year, think about going a little higher, like at least to $50,000 a year. First of all, the salary. Remember that the salary level is scheduled to automatically increase in 3 years, so it'll be above $51,000 in 2020. Also, you might need to expand your range a little as you go because other employees may be indirectly affected, even if they're above the salary threshold. For example, you'll want to look at employees with similar job positions to those in the affected salary range, even if they make a little bit more, if they're slightly higher. And you'll also want to consider salary compression issues and the effects on others in the employee's chain of command, the upstream and downstream effects. So that's just in case adjustments will need to be made to others if their pay is really close to your affected employees. Next, you should start investigating and gathering more information on the affected areas. You're going to need to engage your business unit leaders and as well as managers and supervisors who manage these employees to help in the fact-finding in most cases. So for the employees in question, start investigating to learn more about their actual job duties. Keep in mind that job duties and responsibilities evolve over time. So be open to learning how an employee's job might be different than how it was originally designed or how it's described in a written job description. Don't just take the job descriptions. This is more about what the employees are actually doing today. Also, try to nail down their average hours per week. And I know that can be challenging because you're talking about salaried workers who don't keep time records, but this is really critical for you to evaluate your overtime exposure. You need to assess how much time is currently being worked and how much overtime or time exceeding 40 hours a week the employee works on an average basis to get the job done. So this might require engaging the person's direct supervisor. You need to ask questions like how much time does the employee spend outside of work doing things like checking emails, communicating with the office from their cell phone or their tablet. Is there any travel required in their job? What about on-call time? The point is you need to know how much time is being spent to get the job done, and you need to know about all of it. Also, as you're investigating, start looking into whether the workload is consistent throughout the year or if the excess work, this overtime or extra work, is more of a seasonal thing. Is it triggered by certain factors? You need to understand all of that. Once you know the employees and the areas impacted the most by overtime needs, you can start to consider options for covering the extra work if you had to reduce your employees down to a 40-hour week. So try to think of options for restructuring to absorb the impact, like whether any tasks can be eliminated or redistributed. Could the extra work be redistributed among your existing workforce? Are there employees that are underutilized or who have capacity to take on more? Are there tasks that could be shifted to other teams or other business units? Maybe there are employees who are ready for a promotion, and that could be either by taking on more work to help shift the duties or even to step up to a higher level position that might qualify them for exempt status. Another thing to consider here is whether you have room to add layers or levels within job categories. So if you learn that there are different skill levels or seniority factors that justify different levels of compensation, that could give you more flexibility to make adjustments. So, just for example, some of your employees in IT may qualify for exempt status, and others with very similar titles might not qualify. So you need to give yourself room and have discretion to treat them differently. You also want to consider if the extra work, or what we're calling the overtime work, can be outsourced. In some cases, you can save a lot on payroll if you can isolate out certain tasks that could be outsourced at a lower rate when compared to the overtime premium. You should also consider the option of shifting the extra work to temps or part-timers who could be paid a reduced rate or at least a straight-time rate without the overtime premium. So, of course, all of these decisions can have much bigger implications, and you'll need to carefully consider all your options and what works best for your company. But hopefully this just gives you some good creative ideas as a starting point to approach this. This is also the time to start looking at your existing policies to determine how exempt and non-exempt employees are treated differently when it comes to things like benefits, insurance, and PTO accruals. You want to get a full understanding of the impact it's going to have on your employees to convert them to non-exempt status. Also, this is an opportunity to make adjustments to your policies if you want to kind of close the gap on some of those variances. Like in some cases, you might want to consider differentiating between full-time versus part-time status instead of exempt versus non-exempt, if that's more applicable. In some cases, you're kind of limited when it comes to this, like your time-off policies. And that's because of all the restrictions on docking salaried exempt employees' pay that don't apply to non-exempt employees. You can't get around treating them differently. Also, be careful when it comes to benefits. This is an area where you would want to work with a consultant or maybe a benefits law firm, because there are lots of laws that come into play if you're going to change things there. Also, go ahead and familiarize yourself with state and local laws that affect how you pay your employees. Some states have their own exemption tests and salary levels. State and local laws really kick in when it comes to non-exempt employees. So the biggest example is of minimum wage rates. Minimum wage rates can be higher under state law. They may even be more generous under a city or a county law. Federal contractor employees have their own minimum wage requirements too, so don't forget about that. Non-exempt employees are also affected by state and local laws when it comes to rest breaks. A lot of state laws dictate the frequency and the duration of mandatory breaks for your non-exempt employees, and it's critical that you know these laws and prepare to comply. There's lots of lawsuits around them, and managers need to know how to supervise and make sure that they're being enforced. You also want to make sure you're on top of any contractual requirements that might come into play, things that limit procedures and changes that you make. Take into account government contracts, collective bargaining agreements, and if you have any private employment agreements. And then another thing to start looking into now is your timekeeping system. So by law, you have to keep accurate records, time records for your non-exempt employees. The law doesn't specify, though, what method you have to use. That's really up to you. You can use traditional time clocks that require your employees to punch in and punch out. You can use a paper system where employees turn in timesheets or even scan and email them. Or you might want to consider upgrading to a more modern system with electronic timekeeping that's input directly from the employees' computers or even from their own mobile devices. So timekeeping is a critical part of compliance when you have non-exempt employees. And the law places the burden on you, not the employee, to prove how many hours are worked each work week. So if you don't have strict timekeeping rules and accurate records and you get challenged, it's really tough to defend. It really just becomes a he said, she said, and your employees will say they worked around the clock, or they worked from home, and they worked on the road, or they came in early, and there's really not much you can do to prove otherwise. So it's really important. Also, when you're looking into timekeeping options, think about doing something maybe, if you're in a position to, going with something a little more discreet than the traditional, time clock station that's visible to everyone. So if that's an option to you, especially if some of the concerns that we've talked about with, employees that have to go back to non-exempt status and the stigma that's attached to it. Also, if your time clocks are visible, it can create other issues because, like I mentioned before, with the new salary thresholds in place, a lot of employees are going to be making assumptions about each other's pay. People might jump to the conclusion that everyone punching a clock makes less than $47.5, and those who aren't must be making more than that. And that can really open a can of worms that you probably want to avoid. We know that's not the case. It's not that simple, but anything you can do to smooth that over I think is helpful. Okay, so handling affected employees. Now that you've identified affected employees and analyzed the overall business impact, what are your options for converting them from salary to hourly? And this stage might come a little down the road for some of you. A lot of companies are choosing to wait until closer to the December 1st deadline to make these final decisions because of changes that keep going on with staffing and things like that. But it's a good idea to start considering your options ahead of time. So once you've identified employees that are directly affected and are losing their exempt status, you need to evaluate your options, and you do have some options. First of all, you can try to keep them exempt. This would be a viable option for employees who are close to meeting the minimum salary level, especially if they regularly work overtime. So for these employees, I would do a basic cost impact analysis. Compare what it would cost to raise their salary to meet the minimum threshold, and compare that to the cost of paying them hourly with overtime to get the same work done. So if your calculations show that you're better off increasing the employee's salary to $47,500 to meet the minimum salary level, make sure they meet all the criteria for an exemption and they satisfy the job duties test. Remember, it's not just the salary. If you need to, go ahead and adjust their job duties or their responsibilities to help meet an exemption test. And if you do that, make sure you're taking all the steps to implement those changes, whether it's a formal promotion or just updating their job code or just updating their job description. But remember, it's their actual job duties that count, not what you document their job to be. So I just want to jump in here and remind everyone that salary is not always the best option for every employee, even if they're close to the threshold or even above the salary threshold. So you might not, salary isn't for everyone. As we talked about, salaried employees get their full salary even if they miss work. So, and there are very strict restrictions on when you can deduct from their pay. So it's not always for everyone. And also from a compliance standpoint, if you're on the fence about whether a position qualifies for exempt status, it's always safer to classify someone as hourly non-exempt. Remember, anyone can be hourly non-exempt. If they don't work 40 hours, they rarely work overtime, that is a very safe option that you should consider. I've gone ahead and included the salary basis test and the only deductions that are permitted against the salaried exempt employee's pay. And this is just to help you in that determination if someone's close. Do you really want them to be salaried? You need to think about these things. Your second option, if you don't want to increase an employee's salary to meet the minimum salary threshold, or if they don't otherwise qualify for exempt status and you're forced to convert them, you have some additional options to consider. So first of all, when we say non-exempt status means hourly pay, that's a little misleading. There are lots of ways you can pay non-exempt employees. The key in all the scenarios on this slide is you have to keep accurate records of all hours worked. You have to make sure they get at least the minimum wage for all hours of work, and you have to pay overtime if they work more than 40 hours in a work week. But there are lots of ways you can structure the compensation, and some of them here may really help in the morale department if that's a big concern. Some of these feel like a salary. I just want to let everyone know we are coming up on the hour, and we do have a few more slides. So, and like I said, the slides will be sent to you following the presentation. But we're going to move into the communication plan just as soon as we just breeze through these different options for how you can pay your non-exempt employees. So first, you can leave the person as salaried, and I have that in quotes, but prohibit them from working any overtime. So it would be an agreed upon fixed salary. It wouldn't really feel like such a big change, but you'd still have to track their hours, record keeping, and if they did work overtime, you'd have to pay for it. The next option is very similar, and it may work if there's only occasional overtime. Otherwise, it gets kind of expensive. But this option allows you to pay a, quote, salary for 40 hours of work, but with overtime at the rate of 1.5 times the regular hourly rate, which would be their salary divided by 40. The next one is the most basic approach, and that is simply to convert the employee's pay from salary to hourly. The employee only gets paid for the actual hours worked, and they get overtime at the rate of 1.5 times the regular rate whenever they go over 40 in a work week. So this is also considered one of the more expensive options if your employees work a lot of overtime. especially if you're basing that hourly rate by, on dividing their salary by 40. But here's something very important to consider. The FLSA does not require you to convert that way. You don't have to base it on a 40-hour week. You can actually convert employees to a lower hourly rate to account for the added overtime cost. And that's the next option here. So under this scenario, you can come up with an hourly rate that factors in the overtime costs and arrive at a base hourly rate where the employee's overall take-home pay with overtime would be about the same as their previous salary based on the same number of hours put in. So for example, if the employee typically works a 50-hour week under their current salary, you could come up with an hourly rate that will yield the same take-home pay, taking into account that 10 of those hours will now be paid on an overtime premium. So one of the solutions that we're going to tell you about at the end of the presentation actually does all these calculations for you. It helps you back into the hourly rate that will yield the same annual take-home pay based on different overtime assumptions. One thing to think about with this one is employee morale and retention. If you go too low, the employee is going to see the low hourly rate and they may want to consider other opportunities elsewhere where they can make more per hour. Also, think about the competitive hourly rates, how it affects other employees. You can't just stick it to certain employees and if they all have the same job, you can't come up with different rates based on who works more overtime. And then finally, you also want to keep things in check so you don't go too low. You can't dip below the minimum wage. And keep in mind too, if once you've done it this way and set their hourly wage, if they don't work overtime, then their take-home pay would be less than it used to be. And then finally, this last option here is really kind of tricky. I would just say to work with an employment attorney if you're going to do it. It's the fluctuating rate overtime plan, and it really is a variable so that every week your overtime rate is different. The more overtime worked, the lower your overtime premium, but the employee gets sort of a guaranteed minimum salary to offset that. So it doesn't work in every jurisdiction, so work with an attorney if you're going to use that one. So for employees that you're going to convert to non-exempt, communication is really important. So it's a really critical part of the process. First of all, I would appoint a contact person in the business for employees to go to with questions and concerns. Ideally, this should be someone in HR or upper management. If you're a smaller business, it could be the person who handles payroll or even an officer of the company. But you need to make sure this person understands the laws around exempt, non-exempt status and the new FLSA rules. Realize there's going to be a range of emotions with employees. Some are happy they're going to get overtime. A lot are going to be unhappy for the reasons that we've already talked about. The most important part of your communication is to reiterate that this is all required by a new federal law. It's not the company's choice, not a corporate initiative, not a company objective. I would also reassure the employees that the changes in no way change in their status. It's not a reflection of how much the company values the person or their position. Has nothing to do with performance or rank. It's strictly a change in how employees are paid. It doesn't reflect their value or their status or their career path. And then this next one is important. I've sort of alluded to this, but just so that employees understand that it's not all about the salary hourly designation isn't just about someone's pay level. Some people making above the salary threshold will be non-exempt. Some people making below the threshold might qualify for a special exemption under the law. But just one thing I want to point out here, be careful. You cannot tell employees that they're not allowed to discuss their pay with each other. This would violate the National Labor Relations Act, and there are also specific prohibitions against it for federal contractors, which is kind of recent, in federal contractor employees. So don't tell your employees they have to keep their pay a secret or not to talk about it. That's a right they have. Okay, there are also some administrative tasks that you'll need to tend to when you're converting employees to non-exempt. For example, you need to document the payroll status changes. In some states, there are specific notification requirements, written notification requirements, where you have to let employees know in writing about pay status changes. Depending on the circumstances, you might need to update job descriptions, if you change someone's duties or added new responsibilities to qualify for an exemption. Also, don't forget to implement or upgrade your timekeeping system now that you're going to have more employees punching the clock. And by the way, when I say punching the clock, I just mean tracking their hours. And of course, it can be any method that works for you. The key is that you have accurate records of all hours worked. Also, we talked about the basic communication plan, but there's a lot more you need to share with employees who are becoming non-exempt for compliance reasons, especially when it comes to tracking their hours and following your timekeeping policies. So I've listed some things here that you'll want to cover from a compliance angle. These are to protect you against FLSA claims and to help you manage overtime. So for example, you want to cover things like overtime approval, limitations on off-the-clock work, like checking emails from home, prohibition on comp time. With very few exceptions, non-exempt employees can't have comp time. Break policies, how the employee should report their hours, and what to do when they have changes or corrections to make to their hours. As a best practice, put these timekeeping rules or your wage and hour rules for non-exempt employees in writing and distribute it as a policy. This is something you should have all your non-exempt employees sign off on, signing off that they've read and understood it. And then even more important, I think, is your training for managers and supervisors, the people who are supervising the work of these non-exempt employees, especially if they haven't had to manage hourly workers before. Supervisors play a huge part in FLSA compliance. If they don't manage things tightly, like not enforcing mandatory breaks or allowing off-the-clock work or writing off unauthorized overtime, a big no-no, they put you at risk. So your managers need to understand the basics of the law and to be held accountable for enforcing your rules. There's really so much to cover here. We're actually going to have another webinar later in the summer just to help with this aspect alone, because this is where most of the violations occur with non-exempt employees. The law says, even if you tell your employees not to work overtime, you're required to pay them for it if management knew or should have known that it was performed. Even if an employee volunteers to work off the clock and they get it done from home at night and they're so proud of themselves, you still have to pay for it. So basically the law says if you don't want to pay for it, it's your manager's job to make sure the work is not performed. If it does happen anyway, you have to pay, and you can just address it as a disciplinary issue. So there's a lot to train your managers on here. I've listed most of the major points. You also want to make sure your managers understand that with these changes, there might come some additional tighter supervision, at least for a while, to make sure that all the adjustments are being carried out. They might need to be a little more hands-on and change their habits for a while, like making sure the uninterrupted breaks are being taken and monitoring workloads and schedules and time management. It's definitely a good idea here also to put a policy in place, a written policy in place or a set of rules in writing for your managers that covers all the obligations and have them sign off that they understand and their role when it comes to FLSA compliance. Okay, this is our final slide, and I sort of like to think of this as the silver lining in all this. So like I said, this is a law that has tripped up employers for years, and even companies with the best intentions, this law still gets violated all the time. And as you can see with everything we've gone over today, it's complicated, and there are just so many gray areas to navigate through, especially when it comes to the exemptions. So for that reason, most companies out there, everyone from small businesses to the most sophisticated corporations, are violating this law in some way or another, and probably don't even realize it. It's almost like, I think of it like a ticking time bomb. It just takes one employee to go to the right employment attorney or to the Department of Labor, and as we went over, the exposure is pretty significant. So this law change actually gives you a chance to do a major cleanup, and you get to blame it on the law. So take this opportunity to do a complete cleanup. Go beyond the list of affected employees making under $50,000 a year and do a complete audit. Go through and make sure everyone that's paid on a salary basis, as exempt, qualifies for an exemption, even your most highly paid employees. If they were misclassified, this gives you a chance to make changes with less scrutiny. Also, as part of your audit, document the basis for your exemptions. That will go a long way if you have to defend any of your decisions. And for exempt employees, make sure you have a written salary deduction policy in place. This just explains the salary basis and all the circumstances when you can make deductions, but having the policy itself is really important because The Department of Labor has said that just having this policy in place can create a safe harbor defense for you to help you avoid liability for mistakes if you do make a salary deduction error. Also, if you have any other pay discrepancies, this is the time to correct them. And we went over a few examples, but take a look at equal pay considerations, any unjustified pay gaps, and potential discrimination issues in your pay practices, based on age, race, gender, or any other protected characteristic. Basically, all of your compensation decisions need to be based on objective business criteria. So take a look at any differences and either correct them or document the basis for any variances. So that wraps it up. I'm going to turn it back over to our host for a few final words and some information about the FLSA solutions that I've mentioned. I hope you enjoyed the presentation and you're walking away with some valuable information and action items to help you tackle this new law with a little more confidence. Thanks again for attending, and back to you, Stephanie.
Thank you, Ashley. Before we sign off today, I would like to remind you that ComplyRight has created comprehensive solutions to simplify how you implement the overtime changes that we just discussed. Now available from HR Direct, the FLSA Forms and Tools Kit has everything you need to comply with the new overtime requirements. As you see here, this kit includes a CD with resources and printable forms and a pack of 4 different printed forms as well. You can pre-order now at hrdirect.com. If you're looking for a more robust solution, the FLSA Compliance e-solution includes a printable forms and resources similar to the kit, but includes 4 powerful tools. With the FLSA Classification Wizard, Cost Impact Analysis, Non-Exempt Pay Conversion Calculator, and Salary Plus Hourly Fluctuating Rate Calculator, you can just enter the employee data and you will have the details you need to comply with the new rules and better manage your overtime costs. You may pre-order this solution today on hrdirect.com. If you have any other questions about what we have covered today or the new solutions offered, you may visit hrdirect.com/OT rules or contact the sales team at 800-999-9111. This was an informative session today, and I thank all of you for staying on with us during the hour. Have a great day.